And welcome to this webinar today. And this is the second of our 5 in 25 countdown series on the Procurement Act 2023. And today we're looking at 5 routes to procurement under the Act. So just by way of a quick introduction, my name is Jenny Beresford-Jones and I am a senior legal advisor and public procurement specialist in the procurement team here at Mills and Reeve. Really pleased to be here today with my colleague Shaylee Howard, who is a principal associate and procurement specialist, and also with Dominic Taylor, senior associate, who's got his first outing as a 5 in 25 presenter today. So it's great to have you with us, Dom. Just before we get started, just the latest on implementation of the Procurement Act. So the Act had royal assent at the end of October. So now we are in a countdown to implementation, expected this time next year. Various learning and guidance initiatives being released on the way, as well as secondary legislation, which is going to provide the granular details of how the Act works in practice. And there is an update on that. So we're expecting to see that secondary legislation finalised in March of next year, and also to get some official policy and guidance in February of next year. So that will give us a lot more detail on how the Act is going to work in practice. So we'll be looking out for that and doing training and blog posts on that as well. Do bookmark our reform page, the link's at the bottom of the slide there. All of our materials and updates will be on that page going forward. So I think that's all I will say for now, and I think we can make a start. And Shaylee is going to talk to us first about the first of our routes to procurement under the Procurement Act, and that is running a regulated procedure. Thank you, Shaylee.
Thanks, Jenny. Good morning, everyone. So yes, I'm going to talk about probably the main route of securing your contracts. So running a regulated procurement under one of the procedures provided for in the Act, and Jenny and Dom will talk about some of the other mechanisms. So a key theme coming out of the Green Paper, and one of the sort of criticisms of the current regime, is that the procedures that are provided for are very complex, can be quite cumbersome, and ultimately really do, not favoured by authorities or indeed by suppliers. And the Cabinet Office has really taken this feedback on board and sought to streamline the future procedures that are going to be available under the Act once we've hit the implementation date. So the idea is that these are streamlined not only across the public contracts regulations, but also the concessions regulations and defence contracts as well. So for all types of procurements, you have the ability to use either the open procedure or the competitive flexible process. The key theme here is one of flexibility. So really empowering authorities to design a procurement that fits their needs and fits the needs of the contract. So thinking a little bit about the open procedure, that is, I think, going to look pretty similar to what we've got now, a one-stage procurement process where you have one submission from your interested tenderers, and then that's evaluated and a preferred bidder selected. The competitive flexible procedure is pretty much does what it says on the tin. Really, it's flexible, and there is a lot more ability to design that procurement to suit your needs. So that might include negotiation, dialogue, potentially post-selection engagement, may indeed include demonstrations if that's something that the subject matter of the contract lends itself to, and we are expecting a lot more guidance in this area in due course. And I think the real wish and hope from Cabinet Office is that authorities do use those flexibilities and don't simply sort of revert to type when it comes to designing their procurement processes. There are some caveats, so it's not sort of the Wild West, as it were, when it comes to designing a competitive flexible procedure. The process has to be proportionate, and there is an obligation to consider the nature, complexity and the cost of the contract. So as part of that pre-planning phase, the launch of the procurement phase and the planning phase, it's worth thinking about those things when you're designing your procurement. If we could just move on to the next slide. The eagle-eyed amongst you may have noticed a paper that was published by the Cabinet Office, I think it was last week or the week before, really outlining their innovation ambition, and it's worth a read. And a key part of that is around the procurement processes and the fact that they are sort of innovation friendly, and again, sort of empowering authorities to consider pre-market engagement, considering whether indeed a pilot is a useful idea, or engaging in research and development before you launch your procurement. And Don will talk about direct awards and the ability to have a direct award for a pilot in a bit. There are some provisions to sort of limit that flexibility to maintain equal treatment and transparency. The one I wanted to pick up on was this ability to modify the award criteria. So there is this ability to think about your award criteria at the beginning, but reserve the right to potentially modify those award criteria as the procurement progresses. It will be really interesting to see how that works in practice. There is also, under Section 21 in the Act, an obligation to publish your tender documents in advance. So that's very similar to what you've got now. You do have to publish your procurement documents so that everyone can understand what it is you're buying and what the process is going to look like. But query how you are able to modify the award criteria when actually you've published all your tender documents in advance. So I think that's something that I think we'll need to watch this space and see how that's designed to work in practice. The other last point I want to make before I move on is just thinking about your suppliers as well. I think suppliers will often judge procurement by how well run they think it is and how well thought out they think it is, and the sudden relaxation of the rules means that they are having to bend and adapt as well for each different procurement. So it is worth, as part of the pre-market engagement phase, to consider discussing your form of process with your suppliers to make sure that you're getting the best out of them as well. That's all from me. On to route 2.
Thanks, Shaylee. Yes, so the second of our routes to procurement might be where you'd be thinking about using a framework or a dynamic market under the Procurement Act. And in this area, this is, I think it's fair to say, we are expecting quite a good deal of guidance about how the government intends the new provisions on frameworks and dynamic markets to work. So in some ways, it's a bit of a watch this space. I mean, this is an area where there was quite a lot of noise when we had the Green Paper back in, I think it was December 2021. And now we can see in the Act how that has all sort of translated onto the statute books. So I think essentially we've got your regular framework agreements as we currently know and love them, a maximum term of 4 years, and really designed to operate in very much the same way as they do currently. There's still a potential to have a longer framework if you can justify that longer duration. The Act does say that there would be an implied term into the framework agreement, so that if a supplier who's been appointed has since that appointment become an excluded or an excludable supplier, you can treat them as not part of the framework anymore. So that excluded and excludable are the new Procurement Act terms for suppliers who have fallen foul of the mandatory and discretionary exclusion grounds. There's also confirmation that you can charge a fee, and that would be a fixed percentage of the estimated value of any contract that is awarded under the framework. That, broadly speaking, is similar to what we currently have, but what's new is this new concept of open frameworks. And when this was first consulted on, there was a lot of interest amongst procurement lawyers, and this is I won't claim credit for this. This is Shaylee's beautiful diagram, an attempt to explain how it's going to work. So the idea here is that if you have a framework requirement, and it's on substantially the same terms. You can have successive frameworks up to a long stop date of 8 years, with defined and limited opportunities for new entrants. Where effectively you're sort of reiterating a requirement, it might be useful. If you are planning to change the terms of the framework, then there would be an obligation to run a new procurement. So you can immediately see it's going to work quite well if it's something where it's a very stable requirement. You can run frameworks consecutively, but just take advantage of the opportunity to add new entrants at defined points. The successive frameworks have got to be awarded on substantially the same terms. So that means the award is capable of being made by reference to the same tender notice without substantial modification. In terms of how many frameworks you could have in this 8-year period, it could be annually or biannually, but it must be at least once in the period of 3 years following the award of the first framework, and then at least once in each 5-year period following the award of the second framework. So there are some constraints about how that works. And the frameworks have to be organised so that they succeed one another. So one expires and the other one begins immediately. And there's a total long stop date over the whole arrangement of 8 years. And it would be really interesting to see how it's used in practice. And as I said earlier, where change is needed, or perhaps where you might want to drive innovation or refresh pricing, then I think really you're probably not looking at something of this sort. You're looking at using a regular framework to sort of introduce fresh parameters into the requirement. Quick word on dynamic markets. There is not a huge amount to say at the moment, except just to highlight that dynamic markets is the new name for what we currently know as dynamic purchasing systems. So currently DPSs are not used all that much. The rules changed in 2015 and they're now a little bit more common, but they still tend to be used for commoditized purchases and where there's a growing market. And they are open and they allow new entrants to join, and that's the dynamic element. Going forward, they've been rebranded, as I said, into dynamic markets, and the intention is that they will have application for all procurements potentially, and we do are waiting to see the guidance on what exactly that is going to look like. In terms of how they will work, it looks to be very similar to how it currently works, but one difference is an opportunity to charge a fee. So a bit like with frameworks, a fixed percentage of the estimated value of the contract. And I think the idea there may be that that will cover an authority's costs and actually having to run the dynamic market, and therefore make it more attractive as an option. And just a very quick word on transition arrangements. So transition arrangements are in draft, but what we're expecting the position to be is that where the framework or the DPS is established prior to implementation, then it and all the contracts called off under it, including any modifications or extensions, remain regulated by the public contract regs. And therefore you can see that the public contracts regulations 2015 are going to remain relevant to frameworks and DPSs for many years to come, potentially well into the 2030s. So that was frameworks and dynamic markets. And now I think I'm going to hand over to Dom, who's going to talk about direct awards. Thanks, Dom.
Thank you, Jenny. Good morning, everyone. Yes, I'm going to do a very quick whistle-stop tour through direct awards under the new Procurement Act. What's the same as the old PCR regime? What's new? What sort of things you should be thinking about now? So just to review, the old regulations obviously negotiate procedure without prior publication, Regulation 32. And I think the general view was it was quite difficult for authorities to fit within that regulation. So interesting to see how the new act works. So where are we with the new act? Well, first thing to say, negotiate procedure without prior publication, that's gone, and it's settled on direct award wording, which is always helpful. So it's governed by sections 41 to 44 of the Act, and then it links out to Schedule 5, which we'll come on to. So in effect, there's 3 routes under the direct award route to award a contract. The first of all, which is in section 41, which is the direct award justification route. So a contracting authority is able to directly award a contract when one of the direct award justifications in Schedule 5 applies, and when the intended supplier is not being excluded. That's excluded in accordance with the Act, those mandatory and discretionary grounds. It's worth saying, though, that it is actually possible to award to an excluded supplier if it's in the public interest. And Section 41 includes a test for whether public interest would apply. I don't think we go through it today just because of time constraints, but if you get an opportunity, look through and see if it will apply in your situation. So if we jump into Schedule 5, you'll see that there's a number of direct award justifications, some of which are very similar to the old Regulation 32. So for example, that exclusive rights owned by a supplier, additional repeated goods or services, extreme and unavoidable urgency. But there's also a few additional ones. So if it's a contract for commodities, if it's on advantageous terms because of insolvency, and the point Shirley said before around prototypes and development. Now, if you want to rely on one of these, you jump through to Schedule 5 and you'd go through the tests. And you'll see those tests specifically for the PCRs are very similar to the old PCR tests. And it'd be interesting to see how the courts interpret these. I think the general view is believe that it'll be very similar to start with and then see how it changes coming up. So that's sort of route one, and I suspect the majority of contracts will be directly awarded through that mechanism. But then there's also something which has also been taken from the public contract regulations, which is this switch to direct award. So one of the helpful provisions under the old regulations, 32.2a, was that if you ran a procurement process and you didn't have a suitable tender, you could switch to direct award. So that remains under the new Act. It's under Section 43. And again, there's a test for what constitutes a suitable tender. And when it comes to it, you'd go through that to make sure it applies. And then the final route, third route, is an interesting new one, which has been brought in under Section 42, which allows ministers to publish regulations, which allows distinct contracts to be directly awarded, but it must be necessary to do so. And what necessary is protect human, animal, or plant life, or protect public order and safety. And I think the general view is that this is that COVID situation. During COVID, a lot of authorities struggled to get that Reg 32 test. I think this has been brought in to sort of help in one of those situations. So they're the three real routes: the direct award justification, the switch to direct award, and that direct award to protect life. Little time left, so we'll quickly mention notices. Obviously, new Procurement Act, very, very much all for notices. And there's an obligation to publish a transparency notice in Section 44. And within that notice, you'd set out what you're relying on to directly award the contract. And then obviously, there's a requirement to publish a contract award notice before it's actually entered into. And the interesting thing under the new Procurement Act is there's an obligation to hold a standstill period. It's 8 working days between publishing the notice and entering into the contract. Now, there are exceptions. So if you're relying on the urgency justification or that Section 42 justification, or if you're a private utility, you don't have to have that standstill period. But I think for everyone else, the general view is there will be this standstill period. So even if you're directly awarding, try build that into your program. So that's a very, very quick whistle-stop tour through direct award, and I think I'll hand back to Jenny.
Thank you, Dom. That's great. So what I'm going to talk about is using a vertical or horizontal arrangement under the Procurement Act. Don't worry if you have no idea what I'm talking about. This is the new rebranded name under the Act for what we currently know as in-house contracts or collaboration agreements. Of course, we also know them as Teckal and Hamburg arrangements after the 2 European cases that established them. And where those exemptions apply, they do offer a route to procurement that avoids running a competition at all. So just a bit of a reminder, what are vertical arrangements, Teckal arrangements or in-house contracts. The Act doesn't really change the circumstances where the exemption applies. So there are on the slides a couple of slides of diagrams that set out, broadly speaking, the full situations in which the vertical arrangement exemption applies. I hope everybody admires my my diagram drawing skills there. I'm very pleased with those. But just to briefly give you an overview. So a contract is exempt, first of all, where there is a sort of parent-child relationship between the authority or authorities and the supplier, the company. So that is that the authority, either alone or jointly with other authorities, controls the in-house company. And we'll look at what control means in a minute. And secondly, a contract is exempt where there is a sibling relationship between the authority and the supplier. So essentially they are both controlled by another authority or by another group of authorities. And that's the nature of the vertical exemption, hasn't really changed from what we have in the PCR. Looking at the control test, we can see that we've got the elements of the test to establish the necessary level of control for the exemption to apply. All of these would be familiar if you've ever looked at this exemption, although some of the language used in the Act is different. So, for example, under the Act, you're looking for no one other than the controlling authorities to exert a decisive influence, whereas the wording in Regulation 12 of the PCRs is a degree of control similar to that which it exercises over its own departments. That's gone, and that was taken from EU case law. Clearly, the draftsmen have decided it's not really needed in the new Act. The prohibition on private shareholding is still there, and as is the 8% activity test, so that the company can only do, must do 80% at least of its activities on behalf of its controlling authorities. More on that later. In terms of joint control, it's fair to say the Act gives a little bit more of a steer than the PCR as to how the joint control test is met. So, for example, it tells us that every authority must be represented on the decision-making body, but confirms that one representative can represent more than one authority. There's also wording in there that says joint control would be defeated if the company can do anything which is contrary to the interests of any controlling authority. So those are the vertical exemptions. We also have horizontal arrangements. This is what we currently know as collaboration agreements under Regulation 12.7. And before that, we used to know them as Hamburg arrangements, Hamburg collaborations after the EU case. Again, really, the sort of bare bones of that test hasn't changed. So it's where you have two authorities entering together into a contract with the aim of achieving objectives that they have in common in connection with the exercise of their public functions, solely in the public interest, and no more than 20% of the work done under this contract is carried out other than for the purposes of those public functions. So you've got that 20% activity test there. None of that is really any different to what's in the PCRs. What is different, or which is a clarification, is a bit more guidance on how you calculate those 80% and 20% thresholds in the two exemptions. You won't find it in the Act itself, but it is in the regulations that would be made under the Act, currently in draft, but to be finalised in March 2024. That's the Procurement Act Miscellaneous Provisions Regulations 2024. And it tells you how, broadly speaking, to calculate the activities, and the steer is that you're using average turnover in the 3-year period ending either on the contract award date or in some other equivalent 3-year period that harmonises with the accounting periods and ends not more than 1 year prior to the contract award date. It's recognised that there might not be 3 years of detail available, so there's an option to use credible projections to project forward 3 years. And there's also a recognition that perhaps turnover isn't the best measure. And in that case, the authority can use an alternative measure to assess the relevant activity. So, for example, what costs have been incurred, or how much time has been spent on this activity, or what's the value of the goods that have been transferred under it. So that was just a little word on vertical, horizontal arrangements. Not a huge amount of change, a bit more detail on the thresholds and on joint control. And finally, I think we're just going on to Route 5, which is the light touch regime, and that's Shaylee.
Thank you, Jenny. If we could just move on to the next slide. So there's reference to the light touch regime in section 9 of the Act, and effectively the scope of the Act is set out in regulations. So we've had the consultation of on the regulations, and as Jenny said earlier, we're due to get the final statutory instrument, which will set out all the details early next year. The scope of the light touch regime is referenced by way of CPV codes, or Common Procurement Vocabulary Codes, and that's probably, I haven't really checked, but I guess the only real EU reference that's probably been left in the Procurement Act. The Common Procurement Vocabulary is a European system that categorises goods, works and services. From first glance, it looks as if the scope is very similar. There is a little bit of a curious reference to lots of healthcare services. So the eagle-eyed amongst you will know that there is a separate healthcare procurement regime called the Provider Selection Regime, which comes into force on the 1st of January 2024. And there is some crossover between the two. Just yesterday, we delivered a webinar on the provider selection regime, so look out for that. That will be online very shortly, where we discuss that in a bit more detail. What I'm talking about here is not the healthcare service stuff, but actually all the other services that are still covered by the light touch regime. But the regulations appear to have this crossover, which will need to be clarified. If we just move on to the next slide, the way in which the regulation, the Act deals with the light touch regime is almost sort of by exception, in that there are references peppered throughout the Act, which clarify whether something does or doesn't apply to the light touch regime. So just thinking about some of those. So generally speaking, it's a much more flexible procedure with a lighter set of requirements. There is no requirement to have a standstill period for light touch contracts. However, an authority may still choose to do one voluntarily because it's a good risk mitigation measure. And so that ability is still open to the authority. I'm sure in future sessions we will talk about the reporting regime, and particularly the KPI regime, but that's not something that applies to light touch contracts either. Just moving on to the next slide, there is a little bit of a relaxation in terms of the notices that need to be published as well. So there's much longer time for publication of certain light touch contract details notices and the publication of contracts. This is an area where I think we are likely to see guidance from Cabinet Office. We already have the Transparency PPN, which sets out in detail the obligations to publish notices on Finder Tender Service, but also Contracts Finder, and the time limits that apply to those, whether you're a central government authority or a sub-central authority. And I think, again, this is an area which we might see further updates to that guidance to make sure that there's alignment between the guidance and the Act. And then finally, there's no requirement to publish certain details of any breaches or failures to perform the contract if it's a light touch contract. So lots more flexibility. It might be that an authority still decides to comply with some of those obligations from a risk mitigation perspective in order to be transparent and start limitation periods for any potential claims. But I think at the moment it's useful to know that if you have got a light touch contract, that you have got a lot more flexibility and a slightly easier ride. I think that's me on time. Back to Jenny.
And finally, just a big thank you from Shaylee, from Dom, and from me for joining us. Hope you find it helpful, and have a lovely day today, and do you wrap up warm if it's cold where you are. Thanks very much. Bye.